we've got some important laws that are passed by Congress that establish Indian policy in the very earliest period of the United States, under the United States Constitution. So American Indian policy is shaped by the evolution of the United States federalism, right? The United States federalism is evolving in the 1780s, and then of course with the Constitution it would continue to evolve, because we would get in 1791 the Bill of Rights, first 10 amendments to the Constitution. So federalism is not static. Federalism is changing, and the point of this is to sort of bring you up to speed on some of those facets of Indian policy that are established early on. Okay, so now there are a number of these laws that are referred to as the Trade and Intercourse Acts. They are also referred to synonymously as the Non-Intercourse Acts, and sometimes referred to as the Indian Non-Intercourse Act. I know that's a lot of intercourse, probably more intercourse than even college students are really up to, but non-intercourse, that means, all that really means is there is a division between business or interaction between Indians and American citizens. For the most part, this is what we're talking about. So Congress set the basic pattern of Indian law with these federal statutes that we call the Trade and Intercourse Acts, or the Non-Intercourse Acts. And the more important ones are those of 1790, 1802, and 1834 in terms of Indian policy. So the idea was that under American federalism, under the federal Constitution, 1787, ratified 1788 and then 1789, that the Indians and non-Indians within the boundaries of the United States would be, that all trade between them would be regulated by the state, by the federal state. So whenever I say interaction, I'm really referring to trade for the most part. Interaction, voluntary exchange, whatever. And the idea for this was that the federal government would have exclusive control over trade with Indians in the same way that the federal government would have exclusive control over trade between Americans and foreign powers. The other side of, I mean, the laws did different things, but most of the time they reestablished the same sets of policies toward the Indians. They typically established an existence of a boundary between Indian country and non-Indian country. So Indian country was a zone identifiable by Congress. Land is either Indian country or it has had its Indian title extinguished. Now, why was the federal government so heavy-handed in regard to the voluntary exchange of goods, trade, whatever, between American citizens and American Indians? Number one, the United States federal government would have the exclusive jurisdiction over problems that developed in such trades. So this was an intentionally protected problems that were beginning to arise, or that had long been around between those who were trading with, the Europeans who were trading with Indians, and disputes that would result. So the federal government had jurisdiction over that trade in order to control disputes. The federal government did not want to have Indian wars on its borders. It didn't want its citizens causing revolts locally, in Indian uprisings. So this is why the federal government was given exclusive control. And of course, it was inheriting that same sovereign jurisdiction from that the English crown, the British crown, had lost in 1783. So the Trade and Intercourse Acts tended to prohibit whites from settling on or entering Indian country for hunting or grazing. Now, if you recall, what was remember the Proclamation of 1763? That was not very popular at all with colonial backcountry settlers, because the law was you do not cross the crest of the Appalachian Mountains. That's Indian country on the other side of the Appalachians, on the western side of the Appalachian Mountains. The Proclamation line, as it was referred to, is a boundary established by King George. The idea that any colonial, any non-Indian who crossed that line was in Indian country and was subject to the laws of the Indians. And that meant that the British government was no longer responsible for them and would not come to their rescue if they got into trouble. In fact, the Proclamation line actually made it a capital offense to settle on the far side of the Proclamation line, because that would be stirring up large-scale problems. So look at this. The federal government does exactly the same thing that King George did back in 1763. It establishes a clear jurisdiction between American settlers and the Indians. So if you cross that boundary line, if you cross into Indian country, then the federal government is not going to be responsible for your actions. You're going to have to answer to the Indians. That's what this was all about. In a lot of ways, we talk about the American Revolution and then how the Constitution was sometimes, there are a lot of people who will interpret the Constitution as being sort of a counter-revolution to the American Revolution. This is a good example of that, of how the state took power from the localities and gave exclusive control to the central government, to the federal government. All right. Well, so if you were going to be an Indian trader and you wanted to cross into Indian territory, then you had to have permission from the federal government. So you had to be a licensed Indian trader. You had to be able to have the recognition of the federal government. Anybody who was accused of harming Indian people or illegally crossing into Indian country uninvited would then be essentially subject to a federal crime. And this is really important because we'll see some court cases later where they go all the way back to this. Federal jurisdiction is extended by the Trade and Intercourse Acts over Indian country. And that applies to American citizens doing bad things, acting badly in Indian country. The federal government would even provide some reparation, some compensation to American Indian victims of non-Indian problems. And non-Indians who were accused of stealing from Indians, the federal government would step in and try to correct that situation. And it went the other way as well. But of course, if you're an American citizen and you're causing trouble in Indian country without, and you're not licensed by the federal government, then you're more or less in trouble. So another thing that the Indian or the Trade and Intercourse Acts did was it established the present, and this is, John Marshall would refer to this in his rulings, that the Indian conduct within Indian country would be the purview, the jurisdiction of Indians. So it was not the United States responsibility to create peace among warring Indian groups. Somehow we got away from that one. Now we want to enforce peace all over the world now, it seems like, right? But yeah, this was an early example of the United States federal government saying, if these people are at odds with one another, that's their problem. It's not our responsibility. We're not going to get involved. So, but of course, that would change big time in the future. All right, the United States would become a regulator of. The United States federal government would become a regulator of Indian affairs within Indian country, particularly when it came to Indian tribe acting with other Indian tribes. Okay. All right, so one of the last things that the Non-Intercourse Acts did was to establish a system in which the federal government had representatives within and among the Indian tribes. And this is where we get the Indian office and Indian agents. So the United States Indian office initially was in the Department of War, okay, which today we have the Department of Defense, but it was at the time more like a Department of State. So, the present day Department of State deals with, relationships between United States citizens and other countries, and citizens of other countries and the United States. So that was essentially where this began, is in a relationship of sort of international migration or international movement. But the Indian office would, in the mid-19th century, I think what was the date, 1849, was moved from the Department of War, which was really the Department of State, to the Department of the Interior. So the Department of the Interior would become the primary base for the Indian office, and still is today. The Bureau of Indian Affairs, as it's now known, is a branch of the Department of the Interior. Remember the Indian Removal Act? What do you know about it? Remember, it was 1830 for the most part. It was a law that was popular in the southern states. The Indian Removal Act was a law popular in the southern states, largely because of the cotton frontier. The cotton frontier took off after, the 1790s, when the cotton gin allowed cotton to become a focus of the textile industry in England. So by 1800 is when you have this first cotton boom, the emerging expansion of southern cotton production into Georgia and into Alabama and Mississippi, and outward from the lower Mississippi Valley. 1830s, 1840s. So early on in the 18 teens and 1820s is when you have this this interaction. And you remember the last Trade and Intercourse Act that was relevant to Indian affairs here is 1834. 1830s are really key for the movement of people in the southern states. The Indian Removal Act itself is largely a law that's passed because of the southern Indian presence, the southern tribes, the 5 civilized tribes as they were called. Of course, Andrew Jackson made his presidency, he got to the presidency on that issue. Indian removal would occur, and it was a popular thing in the South. Of course, it made Jackson even more popular than he already was. He has a reputation of, the hero of Battle of New Orleans and so on. But Jackson was, he was not the first president to discuss removal. We've talked about Jefferson before him, and even Washington probably had ideas, but certainly Jefferson with the Louisiana Purchase had ideas about removing Indians to the west, making way for white settlement, allowing Indians to adjust to the society and the economy of this new United States experiment, and things would be rosy. At least that was his hope. The Indian Removal Act, however, and we've talked about this, didn't remove any tribes. It merely authorized Congress to negotiate with Indian tribes for land cessions. Keep that in mind. The law itself did not, the law itself just gave the authority to negotiate land cessions and to grant land in the West, Louisiana Purchase, to those Indian tribes. So recognized title in the case of the Indian Removal Act. Now, we also remember that the federal government has exclusive authority to interact with Indian tribes, and so it would be the federal troops who would have responsibility for removing the 5 tribes, Cherokees in particular, who had the most awful of the 5 removals. Of course, they were moving a larger distance than, say, the Chickasaws or the Choctaws, and they did so over they had very poor timing for the removal. But it was the federal troops who were responsible for the Indian removal. Now, the troops who get the worst rap by the historians when it comes to Indian affairs are not the federal troops. Who are they? Think back to this constitutional stuff again.
Could you repeat the question?
Yeah, if I can remember it. Okay, the federal troops were responsible for removing the Indians. In fact, General Winfield Scott, you ever heard of him? General Winfield Scott was responsible for the Cherokee removal, and he later wrote in his memoirs, I guess, that that was the worst job he ever had was in the United States Army, was the forced removal of the Cherokees. It was, the federal troops had that responsibility to escort them, to remove them and escort them to the West. And, contrary to, maybe popular opinion or Hollywood, the federal troops, for the most part, acted very nobly. So my question was, who gets the bad rap when it comes to dealing with the Indians? And then I said, think back to that constitutional statement about, was the Constitution a counter-reformation? Was it a counter-revolutionary document? Well, in some ways you might say that, because all of the colonies, and during the Confederation Congress, those colonies had their own. Well, they didn't have militaries. They didn't have a standing army. Okay, that was a very important facet of the Declaration of Independence, was to not have standing armies. But now with the Constitution, you're going to have federal troops. It was the militias in Virginia and the Carolinas that were made up of citizens who would often react to problems in the backcountry, frontier issues. Whenever there was maybe an attack on the settlements, what the militia was just it formed quickly, generally of men of families on the frontier, and so it was loosely organized. It was not well regulated at all, and more or less vigilante groups. But that militia facet, that existence of militias, was really central to early American identity. The existence, the presence of a local group of people who would take up arms. And when it came to the removal of the Cherokees in Georgia, in particular, it was the Georgia militia, the state militia, who were blamed for the enforcement of the state of Georgia's policy, where they placed Georgia state law over the Cherokees, and declared that the Cherokees were not competent in a court of law, which opened it up for people forcing Cherokee citizens off their own land, out of their own homes. So the militia was the popular force. The federal troops were actually the ones who were in charge. Now, the federal troops, early on, weren't well funded or anything either. So these are not necessarily extremely highly professional groups of people. But anyway, I wanted to make that point, that the local militias, the state militias, were often the ones that got into trouble with the Indian tribes. They weren't so regulated, and the federal government often, disapproved of their actions. All right, well, we've talked a little bit about this, how the Indian Removal Act was popular in the South. It was popular in the South. It was really unpopular in New England, and this was one of those things that really began to pull apart the country, the states, over, first Indian affairs and Indian removal, and then, slavery would become the next issue with this. So you would have big divisions between the regions, or what the historians call the sections of the country, between the North and the South. Okay, now we're going to jump around here a little bit, but one of the more important rulings that we have that we'll need to pay attention to is this item referred to as ex parte crow dog. And this was a Supreme Court decision, Supreme Court finding that was in 1883. Now, 1880 is really significant, right? What's going on in Indian policy in the 1880s? Okay, this is the period of reform when those New England do-gooders were trying to figure out how to help Indians who were on reservations. And the way that they understood to do that was by allowing them to have their own farms. But then again, they worried that they would get swindled out of their farms by all the surrounding whites, so they created restrictions on the sale of those farms, which created all sorts of problems. But in the 1880s, when these ideas are formulating, this idea of allotment, and getting rid of the Indian reservations, we have an issue out in Indian country involving a couple of Sioux men, Lakota men, and one of whom is known was Crow Dog. Anybody know the story about this? Okay, Crow Dog, you can read about it, but Crow Dog was it was a rival, I guess, of the guy that he murdered, and who was actually a fairly popular, chief. And anyway, Crow Dog shot him. I think he shot him. May have been with a knife, I don't know, but he killed him. And so this happens in in a territory. So it happened on a reservation that was then within the boundary of Nebraska territory. So the question was, when an Indian kills an Indian in Indian country, who's responsible for that? Well, this Supreme Court decision in 1883 was that if an Indian murders another Indian in Indian country, on Indian land, then the Indian is subject to the jurisdiction of the tribe, and the federal courts have no jurisdiction. So in other words, the court says we don't have, they're outside of our jurisdiction, ex parte. All right. So they are not in our jurisdiction, therefore we don't rule on it. Well, what was the ruling? The problem was that Crow Dog killed this rival, and the Indian agents they wanted to make an example out of him, so they hauled him to court. They put him on trial, and they said we're gonna hang you. And when in fact what had happened was he made reparations with the family of the victim, the guy that he killed, and they were happy with whatever it was, some horses and something else, and they said, okay, we're square, we're even. But the courts took it upon themselves to say, no, this was a crime, we need to convict this guy and hang him. And so the appeal then went to the Supreme Court, and the Supreme Court said, no, this is not federal jurisdiction. Indian on Indian crime, even a murder, if it takes place in Indian country, is the subject of Indian law, Indian courts. So we see the emergence of Indian law here. And by Indian law, I mean tribal law. So tribal law is often, even though there were tribal regulations and that sort of thing, the federal recognition of the existence of tribal law and therefore tribal government of some sort is recognized by the courts. Ex parte Crow Dog. Well, of course, that wasn't going to stop anybody. In 1885, we have a congressional act, as you can imagine, saying, okay, well, we've got a problem. We've got Indian country where, the Supreme Court has ruled that the United States doesn't have criminal jurisdiction over Indians. And so they passed this thing called the Major Crimes Act, 1885. And that extended federal jurisdiction over Indian country when it involved murder, so homicide, attempted murder, rape, in any violent crimes. They're referred to as major crimes. So major crimes in 1885 are placed into federal jurisdiction even when it involves Indian on Indian within Indian country. Okay? So this is a really important facet. Congress consciously extended its jurisdiction into Indian country where it hadn't existed previously. So Congress can do that, right? Congress can do that according to plenary power. So they consciously did that. So Ex parte Crow Dog was sort of the catalyst for the Major Crimes Act, and we will refer to these throughout the rest of the course. The Major Crimes Act establishes this federal authority over major crimes. Thus, the FBI gets involved whenever there's, a question. Now, the Major Crimes Act is often referred to as, a conscious interjection of federal authority into the affairs of the tribes, and therefore an erosion of tribal sovereignty within the U.S. federal system. So, an attempt by Congress, or an act by Congress, to dissolve some degree of autonomy among the tribes. So just keep in mind, Ex parte Crow Dog, the federal court, the Supreme Court finds that there is no jurisdiction for the federal government in this case, where Crow Dog is not going to be hanged, and so they pass a law and they extend their authority over him. What do you think of that? Good thing, bad thing? Should they have just left it to the tribes? Yeah, it was. We'll see the consequences of it as we move on. All right, we've talked about the Allotment Act, 1887. You know it as the Dawes Act or the General Allotment Act. It was the federal law, the congressional statute that mandated the negotiation of allotment agreements among tribes. Like the Indian Removal Act, the General Allotment Act didn't allot anything. All right, keep that in mind. All it did was it authorized Congress to negotiate with the tribes to dissolve reservations or to redistribute the land to individuals, and then of course break up the reservations through opening it up to non-Indian settlement, either through sale or land run or lottery or whatever. So again, this was 1887, following for the most part the Homestead Act of 1862, 63. So this was, of course, this was something that was considered to be very progressive and a very good idea by the people who cared for the future of Indian people. But like so many good ideas that had great intentions, it often wound up making things maybe even worse in some cases. So we've talked about allotments and restrictions and that sort of thing. So now the Allotment Act of 1887, right, didn't include the Indians of Oklahoma and a couple more, but the Indians of Oklahoma would have to wait until they would be able to wait until nearly the turn of the century before allotment was imposed upon them. And so this other act, 1898, so you have 1887, 1898, the Curtis Act, formerly known, the formal name is an act for the protection of the people of Indian Territory and for other purposes. So it did not establish allotment itself. It just mandated allotment, and it mandated it leveraged the tribes to negotiate allotment agreements. So 1898, the Curtis Act basically did what the General Allotment Act did, except focused on the 5 tribes. And how would if you were to get an essay question on your second exam about compare and contrast the Curtis Act with and the playing out of the Curtis Act with the Dawes Act, what would you say? What would you identify would be well, we know what the similarities are, right? What are the similarities? Are they neither one of them actually allotted any land. They just forced the allotment of land, or they authorized the negotiation for the allotment agreements. We know that. And, we know what an allotment is, but how are they different in other ways? How are those 2 acts different? How is the allotment of the 5 tribes different from the allotment of, say, the Kiowa or the Cheyenne out in western Oklahoma?
For the Curtis Act, they had the like a time limit kind of thing. So it's like they had to agree to it, or else government would have just done it.
Right. Yeah. Under the Dawes Act, there was pretty much a standard model. So any tribe that went through allotment under the Dawes Act followed that, for the most part, that same plan. Under the Curtis Act, the Curtis Act had the plan. It was the worst. It was the law that was passed intending to be the Indians' worst nightmare. So it was like, okay, if you don't do it by this time, you get this. You remember your parents threatening you like that? What's an example of, if you're not home by 11 o'clock, you're going to lose your keys, right? You'll be grounded for a month. So kind of like that. But, if you don't come up with a plan by such and such date, here's the awful plan that will take effect. Okay? So they didn't want that, so they had to come up with something else. So that's one way in which they differed. So what's another way in which they differed? This is your opportunity to work on the essay question. I wouldn't give you an essay question. Go ahead.
During the Curtis Act, the 5 tribes had more control, or more like negotiating over what their allotments would be.
Absolutely, I agree with you. I didn't think of that one, but that's a good one. In other words, the Poncas and the Otos, they had to find somebody that spoke English, maybe, and maybe that could read, to deal with these government agents. On the other hand, the Chickasaws and the Cherokees, had direct telegraph lines, I suppose, to their lobbyists in Washington City, Washington D.C., and they had people on the payroll who could, who were looking out for their interests in Washington, paying off the right congressman, I guess. It would be a while until all the other tribes would catch up with them on that one, but that's a really good one. That's, they were more sophisticated politically. I mean, that's how they got out of the Dawes Act in the first place, generally. What's another way in which they were different? The allotment process. How are the allotment processes different under the Curtis Act versus the Dawes Act? You guys are really on a roll this morning. Doing really well. But this is a really big one. It has to do with the type of title that the tribes had to the land. Okay. So this is why we need to. This is why the second exam is going to be, covering some of the same stuff. Again, here's a little bit more detail. In the case of the, let's see, the Comanche, Kiowa, Apache down in the southwestern part of Oklahoma. Okay, their lands were opened up, I think, in 1892, or they allotted, 1887. They allotted around 1890 or something, and then in 1892, you had a land run into that area, which is today like Grady County and Stevens County, I guess, and, Caddo County. Maybe not Caddo, it's a different reservation, but southwestern Oklahoma. So you have a land run in 1892. How'd that happen? It happened because the Kiowa, or see, the Comanche, what are they again? The Comanche, the Apache, the Kiowa Apache. Those people, once they got their allotments, left about 98% of the land base of the reservation, right? So that land base was referred to as what? That land that wasn't allotted was referred to as the surplus lands. Great. Surplus lands were federal public domain land, and once the allotment took place, there was no more reservation. Those were just federal lands open to settlement. And so there was a land run in 1892, and everybody claimed it. Now, don't quote me on that. I'm thinking it may have been a lottery. I'm not really sure, but they used to have these. Some of the land. I think that was actually a lottery where they put names in a big hopper. Now, back in the 60s, I remember this, 60s and 70s, on game shows, they used to take names on cards and put them in a big hopper and turn them around like this, and they'd pull out, and you won this. Okay, there used to be things called game shows, in fact. Probably never heard of those. But anyway, that's how they did these land lotteries. You would, put your name and information on a piece of paper, and they would literally throw it in a big hopper, and they would turn it, and they would pull it out, and they'd say, okay, parcel such and such goes to this person, and they get to have that. And that's different, of course, than a land run where everybody's converging on land, and the very best land is fought over, perhaps. And then the Sooners show up the night before. Okay, so they're cheating. So that's the process. That the surplus land's what I was really wanting you to get at. Okay, so how are the five tribes different from that? How did the five tribes allotment differ from, say, the Comanche and Kiowa Apache?
For theirs, they had like two things, so they could have all of their land, and then the surplus land was
Okay,
somewhere else.
why is that?
Because so they didn't have to like move.
Okay, you're on the right track, but I'm going to back up a little bit so that we don't make the water any muddier. Okay, there were no surplus lands. There were no surplus lands. The reason being is because the five tribes had estates. They had been given those lands, granted those lands by the federal government, chartered, patented land. That land belonged to them just as any other land belonged to American citizens. It had been traded, it had been patented to them. That was their property. It was in common. It was a patent to the tribe, so it was common land for the tribe, but it was not United States federal property like the Indian reservation was. And so that land was considered to be an estate. This was why it was so legally difficult to enforce allotment against the 5 tribes in the first place. And the 5 tribes knew that. They said, hey, look, we've got it in writing here. This is our property. You can't take it. Fifth Amendment, right? Fifth Amendment protects it. So when they did enforce allotment, the way that they did it was everybody got a share of the land. Everybody who was a citizen got a share of that land. There was no surplus. There were no surplus lands. But there were surplus. I gotta get my grammar correct this morning. There were surplus allotments, and that was just a bad name. They should have called them like homestead allotment and the allotment that you can do whatever you want to with, the investment allotment or something like that. But basically, all of the tribal citizens were divided. Supposedly, in theory, they got this equal division of land of their entire estate. Okay, so you can imagine. Say you've got 5 kids in your family, and your parents leave you 100 acres. Okay, to be equally divided. How many acres do you get? There are 5 kids, 100 acres. Y'all get 20 acres, right? Okay. But what if it's 100 acres? 100 acres, some's on a hill and overlooks the lake. Some is along the creek. And then there's like an old hazardous waste dump. Who gets the hazardous waste dump? Who gets the land overlooking the lake? The land has different value, all right? So with land that has differing value, how do you divvy up not 100 acres among 5 kids, which makes the math real simple, but an equal share of the land value for the 5 kids for the 100 acres? How do you do that? Well, to do that, you've got to survey that land. You got to get Hunter Chisholm out there doing his land survey work, right? And doing, assessing land quality. And then you've got to say, okay, that parcel on top of the hill overlooking the lake, that's valued at $3,000 an acre. The land over here that's just farmland, we'll say that's $1,500 an acre. And the land on the old hazardous waste dump, what would you say? $100 an acre, right? So that then if you look at the actual valuation of the 100 acres altogether, and what's worth what, okay, so maybe altogether the land is worth $100,000. Okay, then you say, okay, so that means each person gets the equivalent of $20,000 worth of land. All right, does that make sense now? $20,000 worth of land. And so if you pick the parcel up on the hill overlooking the lake, well, you're only going to be able to take a little bit of chunk of that, right? So maybe one person will take that, and they're only going to be able to claim 5 acres on top of the hill overlooking the lake. But the person who takes the hazardous waste dump maybe gets 80 acres or whatever. Maybe they get the whole hazardous waste dump and something else. So the idea here is that is the way, believe it or not, that is the way that these huge estates that we call the 5 tribes, each containing tens of thousands of acres, were distributed among hundreds of thousands of acres, tens of thousands of square miles, among tens of thousands of citizens. Think about how much land quality varies across the Creek Nation. or the Cherokee Nation or the Choctaw Nation. Land quality varies enormously. But the idea was to give an equitable share to each citizen, each person who had it coming to them, who had that equal share coming to them. So it was largely a mathematical problem worked out with their fingers crossed and not very good information. Okay, and then you have the problem of lots of people getting onto the rolls that weren't even tribal citizens in the first place. So that's your answer to the essay question. It's that the thing that we're looking for here is that there are no surplus lands in the 5 tribes because they're estates, because of the patents, and the task of equitably dividing land based on the quality or the value of the land was an astronomically impossible thing to do. There's no possible way it could happen today, I don't think. I don't think you could do it with all of our technology today in an equitable way. So it was a mess. It was, to say the least, it was a very big mess. All right, any questions on that? On an act for the protection of the people of Indian Territory and for other purposes? Let's review this and we'll go. This is Public Law 83-280. What era of Indian policy do you recall this was part of? 1953. Termination, relocation, right? So this was part of the termination era. And what Public Law 280 or PL 280 did was it just like back in 1885 with Ex parte Crow Dog, what it did was it extended state civil and criminal jurisdiction. State criminal, civil, and jurisdiction, not federal. State criminal and civil jurisdiction over Indian country in those states who requested it. Okay? And those initially were California, Nebraska, Minnesota, Oregon, and Wisconsin, and later, 5 years later, in 1958, Alaska. Okay, because Alaska didn't become a state until later. So California, Nebraska, Minnesota, Oregon, Wisconsin, and then later Alaska received authority over civil and criminal jurisdiction within Indian country. This is considered to be one of the very worst examples of Congress specifically eroding tribal sovereignty, or specifically taking autonomy away from Indian tribes. And the really ironic side of this, what is the really ironic side of it? After a while, the states didn't even want it. Okay, that's the irony. So basically, these are the states that received authority over most of the Indian country. You can see that in Minnesota and Oregon, there were some exceptions. So, Warm Springs Reservation in Oregon and Red Lake Reservation in Minnesota, not subject to state authority. So you have what are called today, the legacy of this is that it created it was kind of like a mutation in the evolution of American Indian law. And this mutation is called PL 280. So there are PL 280 states. And a lot of what goes on, a lot of the policy that gets developed will make exceptions for PL 280 states. Okay? But, essentially what happened was you've got the states were given jurisdiction over Indian country within their boundaries. That was and the states would pass their own amendment to their own constitutions to do that. Oklahoma was not one, thank goodness, but a lot of states now still have these issues because they have jurisdiction over Indian affairs when they don't even want it. Okay, so in the 1950s they did this, and then today, in the much later, 50 years later or so, they realized, oh man, this is a huge liability for us. Okay? Should have just left it to the feds. This Public Law 280 was a contradiction to Marshall's declaration in 1832 that laws of the states can have no force in Indian country. Remember that? So the point of all of this review is to refresh your memory that Indian policy, American Indian law, Indian country is subject to this evolution of it's usually Congress creating new laws that make it harder to understand. Of course, the courts try to interpret, the place of these, but